The courts here in Scotland are continuing to restart and progress more civil business, and this week we'll also see the Sheriff Courts start to process and accept new non-urgent civil cases. However, one type of court application that we're unlikely to be seeing a lot of in the near future is creditor-driven winding up petitions. Welcome to Litigation Matters, Episode 4. Last month, the UK government published the Corporate Insolvency and Governance Bill, the aim of which is to support businesses by giving them the flexibility and breathing space that they need in order to continue trading, avoid insolvency and bounce back from the current pandemic. And as part of that package of support measures, the bill introduces temporary but fairly major restrictions on the use of winding up petitions in order to protect companies from creditor action. In summary, these restrictions provide for the following. Firstly, no winding up petitions can be presented after 27th April if they rely on a statutory demand served between 1st March and 30th of June, or until 1 month after the bill comes into force, whichever is the later. Secondly, during the period 27th April to 30th of June, or again until 1 month after the bill comes into force, no winding up petition can be presented unless the creditor has reasonable grounds for believing that either 1, coronavirus has not had a financial effect on the company, or 2, that the company would have become unable to pay its debts even if coronavirus had not had a financial effect on the company. And this has been called the coronavirus test. And finally, winding up orders already made on or after 27th April will be void if they couldn't have been made had the new restrictions been in force. Now, in terms of the coronavirus test, which, as I say, is essentially having to show that the company's inability to pay its debts was not caused by coronavirus, this represents a very high hurdle for the creditor, who of course is unlikely to have detailed financial information about the company available to them in order to assess whether the test has been satisfied or not. Indeed, the government have expressly stated that the test is intended to present a high bar for creditors. Now, this difficulty was acknowledged during the second reading in the House of Lords last week, where one of the suggestions made was that there should perhaps be a presumption in favour of the creditor where the company has failed to engage in good faith with reasonable requests for relevant information. However, that is a change that's unlikely to happen, and the government's position is that it will be for the courts to consider how the test should be applied in individual cases. In terms of the duration of these temporary measures, as I mentioned, they will last until 30th of June or until 1 month after the bill comes into force, whichever is the later. Now, the bill is currently expected to come into force at the end of June, so we'll therefore see these restrictions remain in place until at least around the end of July. However, the bill does contain powers to extend these measures beyond that date should it prove necessary to do so. There was some discussion in the Lords last week as to the end of September perhaps being a more sensible deadline, but the government's current position appears to be to put the restrictions in place for 1 month initially and then have Parliament carefully consider and scrutinise any extension thereafter. But although the bill is not yet law, these proposed restrictions are already being taken into account by the courts in England when presented with winding up petitions. In 2 recent cases, the courts in England have granted injunctions to restrain creditors from proceeding with winding up petitions in cases where the bill, once enacted, would mean that the creditors would fail to meet the coronavirus test, the courts concluding that they were able to take into account the imminent changes in the law which would cover the petitions before them. I said at the beginning of this video that notwithstanding the courts here in Scotland gradually dealing with more and more civil business, we're unlikely to be seeing a lot of creditor-driven winding up petitions in the near future. We're already seeing winding up petitions being restrained by the courts in England because of the impending changes in the law, so there's already a disincentive for creditors proceeding with winding up petitions, and the bill isn't even law yet. And because the coronavirus test which creditors must meet has deliberately been set very high by the government, will creditors think that it just isn't worth bringing a winding up petition while these temporary restrictions are in place, or will creditors seek to try and satisfy the test, and if so, how? I guess time will ultimately tell on these questions, but it's certainly the case that these restrictions being brought in will severely blunt the most powerful tool in the creditor's arsenal, namely the threat of a winding up petition. This has been Litigation Matters. Take care and thank you for watching.